I was talking with a woman last week. Her husband had died previously, and the woman was very concerned about what would happen to their home. I asked a few questions, found out that the home was purchased by the deceased husband, and it was purchased before they got married. And her deceased husband had had one child from a prior marriage, and then had one child with his surviving wife. So I had to explain, because your husband had no will and he bought this house before you were married, his house is his separate property and it's going to go to his two children. I said, if the two of you made mortgage payments while you were married, then I told his surviving wife that she was going to be entitled to one half of the community funds used to pay off the mortgage on his separate property, his house. So the house was worth about $200,000. While they were married, they made about $40,000 of mortgage payments. So that house is going to his two children. She's going to be entitled to $20,000 from his estate, which is one half of the community funds used to pay off the mortgage, but she may get kicked out of her own house, or what she considers to be her own house. So be aware that's one of those situations where it really would have been helpful had he put things in place to make sure his wife had a place to live for the rest of her lifetime, but that's not the case. She's going to have to really get cooperation from his two children to have a place to live. So, but nonetheless, we can't do too much about that. That's part of that estate settlement. When somebody has no will, we have to follow those Louisiana laws that are in place. So be aware of that. I'm Paul Rabalais, and go Tigers.